Hi, my name is Lauren Ellerman. You can see me pictured here with my two law partners, Dan and Bo. This is going to be a very quick video. It's going to be the first of two videos on long-term care in Virginia and some of the legal issues. I am a nursing home abuse and neglect attorney. I represent individuals, so please know that bias and that perspective when we get started. All right, our discussion today, we're going to talk a little bit about the legal differences between assisted living, skilled care, memory care, the types of long-term care facilities, the legal obligations of each, and the legal issues that families face. All right, big picture. Independent living, assisted living, and memory care are not health care. What that means is that Medicare is not paying for them. 99% of the time, Medicaid is not paying for them. They are private pay, and they are not deemed health care under state or federal law. The only long-term care that is deemed health care is nursing home or skilled care in a nursing home facility. Now, why does that matter whether or not something is deemed health care? Well, it matters a great deal because it in fact determines the level of care that your loved one will get. Assisted living facility only legal requirement under Virginia law is to meet the resident's physical, mental, emotional, psychosocial, and spiritual needs. It is not to provide them health care. Nothing in the Virginia Administrative Code says that assisted living facilities need to be providing nursing care, medication assistance, physician assessments. None of that is required. In fact, it's more like a college dorm where the rules regulate the physical environment to ensure safety, but very little else. Interestingly, also under the law, and I hope this is going to be changed if Governor Youngkin signs the bill that is sitting on his desk, it will in fact increase the liability insurance that assisted living facilities are supposed to have. Assisted living facilities, because they're not healthcare, they're not regulated by the Virginia Department of Health. They're regulated by the Department of Social Services. They have very limited staffing requirements, and you will find that even memory care, which is more of a marketing thing than it is a healthcare thing, has very little legal requirements. Memory care in Virginia simply requires that you have staff of 1 to 10. So one staff person for every 10 residents in a locked memory care unit. And that person doesn't even have to be awake at night. So it's interesting that many people think when they're signing up their loved ones for memory care, they think they're signing their loved ones up for health care. They are not. Now let's move on to skilled care. Under federal code, skilled care is in fact deemed health care. That's why it's paid for by Medicare for the first 100 days, and then after that, often by Medicaid. Virginia law also has to do with skilled care, and it will talk about rehab. That's the first 100 days, and then if you become a long-term care resident thereafter. $1 million in liability insurance right now. Again, there's a bill on Governor Youngkin's desk as I record this, March of 2025, that would increase that liability to meet the medical malpractice cap. In long-term care, that's after day 100, Medicare will not pay. You're going to live in the nursing home for the rest of your life. It's either going to be paid for by Medicaid or it's going to be private pay. It's a great thing to do if you want to make some money in Virginia. According to Virginia Business Magazine, at least 15 nursing homes in Virginia made over $20 million net in 2024. That's $20 million net. It is a very popular for-profit business, and that is the difference between assisted living and skilled care in Virginia. Thanks so much for your time.